Hello, you're watching the EEO compliance training for the Bridge Academy. This is Josh Cosner. I'm the Director of Quality at Connexus. Just to give you a little bit of background information about myself, I have an IT background, so I worked with computers for a lot of years. I've been with Connexus for approximately 6 years. My role is kind of an internal consultant, so I work a lot in all parts of the business, including the Bridge Academy. And I am our EO officer, which is the Equal Opportunity Officer. So what we're going to do during this webinar is we're going to briefly review and discuss major anti-discrimination laws. We're hopefully going to increase your awareness of workplace harassment, including types not so obvious. We're going to learn some techniques for identifying and preventing workplace harassment, discrimination, and retaliation. Going to understand a little bit about reasonable accommodations, and this is for your time while at the Bridge Academy as well as when you enter the workplace elsewhere. Okay, so throughout this, in the live version, everyone gets an A, B, and C piece of paper, and after each quiz that we'll go over, you can throw up your A, your B, or your C, depending on which one you think it is. So it's very much like an auction at the bottom right here. So just to overview some of the anti-discrimination laws, started back in 1963 with the Equal Pay Act, and what this was wage or payment discrimination. Essentially, it was ensuring that men and women who performed the same work were paid the same, because before that, 1963 in the EPA, it was a problem. Then probably the largest and most well-known anti-discrimination law is Title VII, and that's the Civil Rights Act of 1964. This is the one that prohibits discrimination in employment on things such as race, sex, color, religion, national origin, and retaliation. That's kind of the big one, 1964. Then there was the Age Discrimination in Employment Act. This is one that protects those 40 years of age and older against employment discrimination. Then in 1973 was the Rehabilitation Act. You may know it as the ADA. It's commonly used. It's to prohibit discrimination against those individuals with disabilities, both seen and unseen, so visible and non-visible. And it also puts in a provision about a reasonable accommodation, which we'll talk about later. And then to those qualified individuals with disabilities, so to make sure that their disabilities don't get in the way of them performing or applying for a job. Then in 1991 was the Civil Rights Act update of 1991. This was really about getting monetary damages in the case of employment discrimination. So if you are discriminated against and you have a case and you win, you may be entitled to monetary damages. And then in 2003, the last major anti-discrimination law was really about whistleblower activities. And whistleblower activities means that if you are discriminated against and you speak up about it, you can't get hurt by that activity. They can't fire you or give you some kind of unfavorable terms or unfavorable treatment because you spoke up about being discriminated against. Okay, so those are the major discrimination laws. So here we can pause the video if you want. This is a question 1. Which one is not a protected class? In other words, is not protected by anti-discrimination laws? Is it race, is it sex, or is it political party? The answer is C, political party. Although it is something that is very common, it is not protected by the anti-discrimination laws. And the second question, what year was the Civil Rights Act first introduced? 1776, 2008, or 1964? 1964 was the year the Civil Rights Act was first introduced. Next, we're going to look at disparate treatment discrimination. This is when two similarly situated individuals are treated differently because of their membership in that protected class. So in order to do this, you, 1, have to be a member of that protected class. You have to suffer some kind of adverse action, i.e. something bad happened to you, something negative. And then a third thing to establish prima facie is that somebody that is similarly situated as you, i.e. has the same skills, is treated more favorably. So there's that comparison example. So an example of disparate treatment discrimination. Johnny and Terrence are both plumbers and both came from the same apprenticeship class. So they have the same skills, they have the same experience, they have the same knowledge, and they can perform the job just the same. But when it comes to work assignments, Johnny consistently does not get assigned to jobs in a higher paying or rich part of town. Because when he asks, his supervisor states, "We don't want to scare the rich folks by sending in a young black worker." So this is an example of disparate treatment discrimination, where we have two people that are similarly situated. Johnny and Terrence both have the same credentials, both have the same experience and the same knowledge. But yet, one, because of his membership of a protected class, i.e. his race, Johnny is discriminated against. So he's getting treated differently. So remember, you have the three different conditions, right? You have to be a member of a protected class, which Johnny is. You have to have an adverse action, which is not getting or getting less favorable assignments. And you have a similarly situated person, Terrence, who does get treated differently because he's not a member of a protected class. So that is disparate treatment. So on a quiz, what is disparate treatment? Disparate treatment. Is it unfair treatment based on behavior or performance? Is it when similarly situated individuals are treated differently because of their membership in a protected class? Or is it when similarly situated individuals are treated the same? B. Disparate treatment is when similarly situated individuals are treated differently because of their membership in a protected class. Next, we're going to talk about adverse impact discrimination. This is when it's a facially neutral employment policy or practice disproportionately impacts members of a protected class. In other words, it's when a policy or procedure or practice doesn't necessarily mean to be discriminatory, but it disproportionately affects negatively someone in a protected class. And typically the employment agency, the company, has to provide some kind of justification as to why this is needed. And if there is a reason, or if there's not, they have to have an alternative practice that is less negatively impactful on that protected class. And again, for adverse impact discrimination, discrimination is not required in terms of motivation. It is typically a facially neutral, or on its face is not negative. So an example, the job description for a receptionist states applicants must be able to lift up to 100 pounds at a time. On the surface, when you look at it, that may not be uncommon for some job descriptions, say a railroad worker or a construction worker or somebody that's a roofer that has to move heavy equipment, heavy material. But this may have an adverse impact, a negative impact on some members of a protected class. For example, it may negatively affect women. It may negatively affect those over 40. It may negatively affect those with disabilities, especially physical disabilities. But yet it does not take away from the job of a receptionist. Can you do a receptionist job without being able to lift 100 pounds? My guess is yes. Did they put it in here for maybe a real needed reason, such as being able to move, boxes of paper at a time? Yes. So that's where the alternative action and description differentiation must be able to move paper, or as an accommodation, you can use a dolly or you can use a cart to move the paper as opposed to lifting it 100 pounds at a time. So again, what is adverse impact discrimination? Is it when a facially neutral employment practice or policy disproportionately impacts a member of a protected class? Is it motivated discrimination against members of a protected class? Or is it an employment policy practice that impacts everyone equally, regardless of their status in a protected class? The answer is A. It is when a facially neutral policy disproportionately affects a member of a protected class. Next, we're going to look at workplace harassment. Harassment is any unwelcomed verbal or physical contact based on race, color, religion, sex, again, regardless if it's whether it is of a sexual nature, sexual orientation, national origin, age, disability, or retaliation that is sufficiently offensive to alter the conditions of the victim's employment. This is met when there is a tangible employment action or it creates a hostile work environment. So examples of workplace harassment: calling someone racially insensitive names, making offensive jokes towards individuals' religion, constantly referring to an older employee as Gramps or Old Fart, or unwanted catcalling towards a female trainee. Catcalling is like hooting and hollering as someone walks by. So what is workplace harassment? Is it any unwelcomed verbal or physical conduct based on a protected class that is sufficiently offensive to alter the victim's employment? Is it playful teasing from one person to another? Or is it physically assaulting one another? The answer is A. Workplace harassment is any unwelcomed verbal or physical conduct based on a protected class that alters the conditions of the victim's employment. Now we refer to tangible employment action. What is a tangible employment action? Well, that's really just a significant change to an employee's job or their employment. This could be something like hiring someone or firing someone or a promotion or failing to promote when they're due a promotion or demotion. It was an undesirable reassignment, as in putting them on a not as good of job or not a utilization of skills, or others. So this is when you change somebody's job, tangible employment action. So an example: a manager pressures a subordinate to join her for dinner and dancing. When he declines, she says that how can she expect to mentor him if he's unwilling to spend time after work hours? But after he doesn't relent and he says no, he receives an undesirable reassignment. In this instance, the undesirable reassignment represents a tangible job action. So even if it just happens once, this conduct is lawful or is unlawful. So he was being potentially harassed at work. He declined, and then he suffered a tangible employment action. He suffered a change in his work environment as a result of that. So what is an example of a tangible employment action? Is it another trainee makes a racially offensive remark towards you? Is it someone who hands you a Playboy magazine or something tangible and you find it offensive? Or when you get invited to church by your manager, who is of a different religion than you, then you decline, and then your manager is upset. When you get to work on the next Monday, you learn you have been demoted. Let's see. This is an example of a tangible employment action. So a hostile work environment. What's important to know about a hostile work environment is anyone in the workplace can commit this type of harassment. You, a non-employee, a manager, a coworker, anyone can. And it must rise to the level of either being severe or pervasive. When you're talking about severe or pervasive, you're talking about the two frequencies and severities. So if the conduct is more severe, it doesn't have to happen as often to be a hostile work environment, i.e. it can be a very traumatic, severe incident and only happen once. That would be very severe. Or it could be the less severe kind of conduct, something smaller, and over time it builds up, and it does it enough to constitute a hostile work environment. And that means pervasive, that it doesn't happen very seriously, but it happens a lot, and over time it builds and makes it pervasive, which can be a hostile work environment. Or it can be anywhere on that spectrum in between. So the agency is liable for allowing a hostile work environment to be there unless they can establish that they took reasonable care to prevent it and promptly correct any harassment, i.e. has a anti-harassment policy and a complaint procedure, or address the issue, or if the employee or the aggressor the complainer or the person that brings up the harassment unreasonably fail to take advantage of any corrective opportunities. In other words, they didn't tell anybody, they didn't follow the complaint process, they didn't do their part. So who can create a hostile work environment? Your boss, a coworker, or both? The answer is both. Anyone can create a hostile work environment. Next is the reasonable person standard. A reasonable person standard is used in evaluating whether the unlawful or unwelcome conduct is sufficiently severe enough or pervasive enough to create a hostile work environment. But it also does so from the standpoint of a reasonable person. And the reason that they do this is that it guards against people who are hypersensitive to various subjects, where it may be offensive to them, but if you ask anyone else or a reasonable person, it would not be offensive, it would not be harassment. So what does the reasonable person standard protect against? Lawsuits, claims against hypersensitive individuals, or the gum disease gingivitis. B. Reasonable person standard protects against claims against hypersensitive or very overly sensitive individuals. Harassment by coworkers. If a coworker creates a hostile work environment, again, the agency is liable if they knew or should have known about the action and did not take immediate and appropriate action. An example of a misconduct by a coworker. Perhaps when a female complains about the vulgar language and jokes that routinely fill the break room, her male coworkers tell her to lighten up and get used to it because that's how the boys behave. That is harassment by coworkers. Harassment also includes religious harassment. Again, it's religious harassment is discriminatory treatment based on a person's affiliation with a particular religious group, display or physical or cultural traits commonly associated with a particular religion, perception or belief that someone else is a member of a religious group, whether it is true or not, dress or commonly associated with a particular religion, or even in association with a religious person, individual, or organization. So at one point, everyone is a member of a protected class. Some may be obvious, some may not. Some of the more obvious or more prevalent forms of protected class are race, are gender or sex, or disability. But again, with religious harassment, even if it's association with a religious person or a specific group, and you are discriminated against because of that association, you would be protected under that protected class. So for instance, I am a white male under 40. I am generally not categorized as being in any member of a protected class. However, if I have a friend who perhaps is a Muslim and I am discriminated because of that, I would be covered under that protected class. So prevention of harassment. So avoid initiating or participating in any of the behavior that may be misconstrued as harassment. So things like verbal, as in unwelcomed comments or yelling or offensive jokes or stories. Maybe it's visual, where it's visual offensive pictures, photographs, cartoons, calendars, magazines, or objects. Whether it's physical, unwelcome touching, hugging, stroking, ogling, suggestive gesturing, or even written, where it may be unwelcomed letters or emails or notes or text or Facebook. So again, to prevent harassment, avoid those sexual or racial or ethnic or cultural or disability-related jokes, epithets, comments, or emails. And if someone wishes that he or she doesn't like the conduct, respect that person's wishes. If you are finding it offensive or being harassed, you have to clearly inform those engaging in the offensive behavior that you find it objectable, i.e. speak up, and report the behavior that you believe qualifies as harassment. And a rule of thumb is if you have to ask whether it's harassment or not, it is. So what is an effective and reasonable way that you can prevent harassment in the workplace? It's to not come in at all to work, is to not tell offensive jokes in the workplace, or to not talk to anyone while at work. The effective and reasonable way to do this is to not tell offensive jokes in the workplace. Although A and C, not coming in or not talking to anyone, would potentially prevent you from harassing, the best way and most reasonable way is choice B. When we talk about reasonable accommodation, this is just effective adjustments to a person's work environment to help them perform the essential functions of the job and the applicants to participate in the employment application process. So, no individual employee with a disability can be denied either the benefits of a program or training by Connexus or any other entity. To that end, reasonable accommodation will be provided to individuals with disabilities unless this poses an undue hardship to the agency. An example of an undue hardship is if there is a 2-story building where there's no elevator, and perhaps some of the team meetings are upstairs, which require you to walk up the stairs, and there's an individual in a wheelchair who is not able to get up the stairs. A reasonable accommodation that would not provide undue hardship would be to provide and do the meetings downstairs. Perhaps putting in an elevator, which costs hundreds of thousands of dollars potentially, could put a burden on the agency, i.e. put them out of business or help them, force them to fire someone to be able to pay for it. That would be an undue hardship. So that's the reasonable accommodation to accommodate the person. Some key notes is there's a wide range of possible accommodations, and it may not be the one exactly that they requested. The goal is to accommodate the individual and solve the problem, not necessarily exactly what they wanted. So a reasonable accommodation for an employee is an effective adjustment made to a job or work environment that enables qualified employees with disabilities to perform essential job functions. It is a law in 1964 that states employers must reasonably accommodate any employee requests, or is it C, a hotel? Reasonable accommodations is A, an effective adjustment made to a job or work environment that enables qualified employees with disabilities to perform the essential functions of the job. When we talk about disabilities, so the definition of a disability is an individual with some actual disability that is physically or mentally impairment that substantially limits a major life activity, or an individual with a record or history of an impairment, or an individual who is regarded as having such an impairment. So either they have something that limits a major life activity, which we'll discuss in a moment, or it's a person that has a history of that impairment, i.e. they used to have back problems or used to be deaf before they got adjustments, or it could be someone who is regarded as having such an impairment, i.e. they may not identify as having a disability, but it's obvious and they're regarded as having an impairment. An example of this will be someone who doesn't say they have a disability, but they have a problem opening doors because of their back. Even though they don't say they have a disability, they are regarded as having a disability or impairment. So physical and mental impairments. Typically, when we think of disability, we think of physical, things that you can see, things people in a wheelchair, somebody that is blind or missing an amenity or an appendage, such as an arm or a leg. But there are also mental impairments, things that you may not be able to see, including a condition or disfigurement of the body, or a mental disorder, a psychological disorder, such as retardation or mental illness or learning disabilities. Those are considered still a disability. And when we talk about major life activities, under the ADA, major life activities are including but not limited to things like caring for oneself, seeing, hearing, concentrating, breathing, communicating, and it can also include operations of the major body function, as in a weak immune system, or digestive issues, or brain issues, or respiratory or circulatory issues. It does not have to be something seen, but if it does help, it does prohibit them from doing a major life activity, things that most individuals don't think twice about, as in walking or going to the bathroom or reading or talking, that it may limit a major life activity. So an example of a disability is someone who can't dunk a basketball, someone who is under 5 feet tall, or someone who can't see or is blind. See, someone who can't see or is blind is an example of a person with a disability. When you are making requests for accommodation, you can request it from your supervisor or an immediate chain of command. You as an employee may have a representative, like a doctor or a family member, request it for you if you're not comfortable with the process. What the person will do is they will acknowledge your request and take immediate action on it and review and evaluate and make the decision, make the accommodation within a reasonable time frame. So again, reasonable accommodations can include things such as modifying a work site physically, providing readers or interpreters, providing extra headphones, assistive devices, flexible leave schedules for medical issues, again, modifying the work schedules, or making accessible facilities, things like installing ADA ramps or special desks for those in wheelchairs. And under this reasonable accommodation comes the religious accommodation. Again, this is for sincerely held religious beliefs and practices that they should be accommodated without doing undue hardships. So things like allowing employees to make up hours, or allowing special religious dress, or granting them time or places to pray, or observing their religious holidays or observances, are examples of religious accommodation. So what is an example of a reasonable accommodation? Is requesting Beats headphones so you can listen to your work? Is it asking to move your work schedule because you always sleep in past your alarm? Or is it requesting an alternative keyboard with larger keys because you have problems seeing? The answer is C, requesting an alternative keyboard with larger keys. Although A, you may have hearing problems or may need to be reasonably accommodated, getting Beats headphones may not be the only source of solving the problem. In other words, if you need headphones to do your schoolwork, but Beats headphones are one of the options and that's what you requested, that doesn't mean necessarily that when you request them, you will get them. Again, the point is to be able to solve the problem and to reasonably accommodate so you can perform your schoolwork. When we talk about retaliation, this is when you face discrimination or remember the disparate treatment, or you're a member of the protected class and you're filing a complaint. And then there is a connection between that activity and discrimination. So to be a retaliation is you have to be a member of a protected class, and there has to be a protective category or activity, such as filing a complaint or letting people know about discrimination. And then there has to be some kind of negative adverse employment action. And there has to be a causal connection that if you didn't do the complaining, that you wouldn't have gotten punished. That is a causal relationship. Again, typically they're linked, and it happens shortly after the protected activity, such as filing a complaint. So when you're filing a grievance, this is at Connexus's policy, which is almost universal everywhere you go. You just must fill out the form, which includes things as the full name and address, a concise statement of the facts, provision of the act or the grant or the contract or other agreements you've been violated against, perhaps something like WIOA or Youth Build or the Bridge Academy, and then the relief requested, which is what you would like to see as a result of this grievance. And then it must be delivered to myself or the EEO officer with the organization. And when I or the EEO officer gets it, it will be reviewed and will enter the complaint process. An example of a retaliation is Burlington Northern versus White. Burlington Northern is the organization, and Miss White is the person's name. So on June 2006, this rendered a significant decision in retaliation. So the facts were that White was a woman, and she was the only woman working in her department operating a forklift in a Tennessee lumber yard. She complained of sexual harassment to her immediate supervisor, and when she did, her supervisor was disciplined. After that, she was removed from forklift duty to a less desirable and more arduous and dirtious duties as a track laborer, although her job classification remained the same. Then she was suspended for 37 days without pay for alleged insubordination, but was eventually reinstated and given back pay in full. So Burlington asserted that Ms. White did not suffer any adverse employment action because she was not fired, which is true. She was not demoted, which is true. She was not denied promotion, which is true. And she was not denied wages, which initially they were, but then they back paid her. But the court held that White suffered retaliatory discrimination when she was reassigned. Remember when she spoke up about sexually being harassed, and then her supervisor was disciplined. And after her supervisor was disciplined, she was put on a dirtier job. So although they were the same job, in other words, she was still a forklift driver technically, and she received the same pay, and she was eventually reinstated, the actions were sufficiently harsh to constitute discrimination because of that act would perhaps deter someone from using the complaint process. In other words, if another female coworker saw that Ms. White spoke up about discrimination and spoke up about being sexually harassed, that she got in trouble for that and she got, put in a bad job for that, that would make them think twice about doing some kind of discrimination complaint. And the idea is to not be able to discriminate based on that. It's against the law to be able to withhold information or prevent people from speaking up about being discriminated against. So that concludes the EEO officer training for the Bridge Academy. So reflect on what was some things that you learned. And the EEO compliance training for the Bridge Academy promotes equity, equality, diversity, and inclusion in the workplace to build a stronger connexus in our communities.